Good to go? All right. We're going to call this special commission meeting to order. Carly, if you can do a roll call, please.
Nidinger?
Here.
Thomas? Here. Thompson?
Here.
Reed?
Here.
Penny?
Here. Good evening, everyone. Thank you for joining us. We're going to begin tonight with a special commission meeting during which the City Commission will be sitting as the local planning agency. We will be conducting public hearings for 2 proposed ordinances. At this time, I'm going to ask the city attorney and the city clerk to speak regarding the hearing process for both items on the agenda. The city attorney will inform everyone of the records hearing as follows.
Thank you. All evidence admitted at these hearings will be kept by the clerk to remain as part of the record. In accordance with Florida statutes, you are hereby notified that if a person desires to appeal any decision made by this board in these hearings, he or she will need a record of the proceedings, and that for such purpose, he or she may need to ensure that a verbatim record of the proceedings is made, which record includes testimony and evidence upon which appeal can be based.
If you are planning to speak during this evening's meeting, if you could stand and raise your right hand, please. And you can just respond accordingly. Do you affirm that the testimony you are about to give before this commission will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. There were comment cards on the sign-in table. I'll collect those if you come to speak. If you didn't get a chance to fill one out, I've got extras up here. Just want to make sure that you have those. Thank you.
Okay. That's item number 1. This is ordinance number 2024-03, and I now open the hearing for item 1 and ask the City Attorney Mandel to present it on behalf of staff.
Yes, thank you. The item in front of you, which is item number 1 on the special commission meeting, is for the purposes of the amendment to an ordinance. This is an amendment, proposed amendment to an ordinance amending chapter 130-10 and 130-12 of the City Code of Ordinances. This is only to discuss the ordinances. This is not to discuss any other items that are on the agenda tonight, so I want to make that clear for the purposes of the record. I also want to say for the purposes of the record that I did hold a town hall meeting upon discussion where we did also talk about the ordinances, but we talked about other matters as well, so that we had an opportunity to any interested person so we could discuss and describe the purpose and premise behind my recommendation of adopting this ordinance. The intent of the ordinance, which amends, like I said, both 130-10 and 130-12, relates to the provisions of the City of South Pasadena zoning code that allow as a special exception permit non-profit community uses limited to public parks and playgrounds, docks and boating facilities of a private nature. As I have previously discussed, as we were going through other processes relating to the action on the Causeway Village docks, it came to my attention, and as I've stated to the commission, that there might be some underlying legal issues as it relates to the terminology and making a land use decision of a non-profit community use. The concern that was raised as part of that discussion is whether or not a municipality has the authority to regulate the use of land by regulating the ownership interest of that land. That is an issue that we have discussed previously at the first reading of the ordinance, and we did discuss at some length during the town hall meeting. As a result of the town hall meeting and questions regarding my legal analysis on that, there is a memorandum that was submitted as part of the record. It doesn't draw a conclusion, but it certainly does provide the background case law that I looked at as it relates to this particular issue and why I'm making the recommendation to change our code. The amendment that I am recommending is to remove the term both as for the mobile home residential district, and this is also the same as the residential multifamily district, to remove the term nonprofit and add in accessory uses to serve a residential community. In addition, as it relates to the docks, and it's the same for both provision, that it is clarified that the docks and boating facilities are of a private nature for use by the residents of the residential community it serves. By removing the term nonprofit, which would have the effect of regulating who the owner of the land is, versus regulating the way that land is used for the purposes of being an accessory use and for the purposes of being the being an allowable use for the purposes of serving a residential community, it is my opinion that is more legally defensible and also is in line with the intended outcome of these special exception permits. So unless there's any additional questions, as I previously stated, that's my recommendation. It's based upon some of the case law that I've put into the record, as well as other discussions that we have had. And with that, I will take any additional questions from the commission, and then it can move on into the next phase of this public hearing in front of you as the LPA. Thank you.
Does anyone have any questions this evening? Okay, thank you, Julia. At this time, members of the public are now invited to comment on the item.
And I want to remind everybody who's speaking, this is a public hearing only on the ordinance, not on anything related to the special exception.
Do I need another card for the
conditions
other one?
Causeway Village.
Because I'm going to speak at the other one? Okay. So I didn't know.
If you can just start your comments with your name and address, please.
Okay, okay. Ready? Good evening, Commissioners. My name is Sandy Chapetta, and I live at 3717 46th Avenue South, St. Petersburg, Florida. My comment is leaving City Codes 130-10 and 130-12 as not-for-profit private use protects the public interest by preserving the zoning district's residential nature and protects public safety by ensuring that the revenues collected from all multi-residential docking facilities are only used as reserve funds to maintain, repair, and replace the docking facilities and are not siphoned off as profits. Residents have testified at public hearings for years the docks weren't maintained in safe condition. Even though a landowner's use of his land should be what is most favorable to the landowner, the use must also be compatible with surrounding uses. All the docking facilities in this part of the bay are restricted to private resident use only, with no public assets and no commercial uses allowed. And the Causeway Village docking facility should have the same restrictions using this code, the previous code I meant. There is no need actually to change the city code. In an email to the city dated 12/7/2021, Mr. Ebellini's complaint was that the owner wouldn't be able to profit off his submerged land if ownership was transferred to a nonprofit association. He also proposed a solution. Both of the city's stated objectives, a nonprofit community use and remain private for use only, can be accomplished by tying the ownership of the land and the docks to the upland owner and the recorded restriction with the other conditions in the document. See attachment 1, and this is the attachment. In an email dated 9/17/2016, the developer asked if there is any way slips can be rented out to the public or if the docks could be an accessory use, which is what the code is being changed to. Note the words accessory use, and here we are. He asked way back in 2016. Then he wrote, any future redevelopment would capture the use of the docks relative to whatever upland plan was conceived. Is the city opening the door for a private docking facility to become a public docking facility by changing city code to accessory use? That would then permit commercial uses within residential zoning districts where they would otherwise not be allowed. If city code is changed and public access is established via public kayak rentals, is there a court ruling that would allow the owner to force the city to remove the permit conditions to allow the slips to be rented out to the public if the code is changed to accessory use? Will changing city code allow the public to access the 80-foot dock, observation deck, and kayak launch as a commercial accessory use when the code is changed, even though permit conditions restrict the docking facility to no commercial use? We also asked if other multi-residential communities will be able to remove their nonprofit status and charge for-profit rates, and the answer was yes. Before making this code change, the commissioners should pause tonight's vote and know the answers to these questions so it's clear what the future consequences of changing city code will be. Thank you.
Thank you. Okay. She's got it right now.
Just whenever you're done with it, if I can take that back, no rush, I just need to make sure I get it at the end of it.
Okay.
You can start with your name and address.
My name's Robert Cavello. I live at 7115 14th Avenue South, South Pasadena, Florida. And I think I want to ask, does changing the city code for docking facilities from not-for-profit to accessory use allow any commercial uses that could change the residential nature of Causeway Village and other residential communities by granting access to the public? And another question is, if the city code is changed to accessory use from not-for-profit and public access is established via a public kayak rentals, is there a court ruling that would allow it to force the city to remove the permit conditions to allow the slips to be rented out to the public? And what other commercial accessory uses would be allowed in the Causeway Village and other multi-residential districts if this is changed? Thank you.
Thank you. Is there anyone else who wishes to speak?
Linda Cavillo, 7115 14th Avenue South, South Pasadena. After the town hall meeting, I'd like to address the Strommel and versus Columbia City. That was the case that the city attorney had based some of this stuff on. And I'm addressing the question concerning the city code everywhere states residence use only for multi-residential docking facilities. Would the Strommel versus Columbia City Court ruling override all city codes to allow public access to the 80-foot dock, observation deck, or a Causeway Village kayak launch for public rentals? The second thing is, if the permit conditions don't restrict public use of the 80-foot dock and kayak launch, would the owner need a permit to operate a public kayak rental business utilizing the Causeway Village dock and kayak launch, and would there be a public hearing for that permit? My other question to the attorney is the conditions that we went over during the town hall meeting. Are those conditions non-negotiable?
I don't think it's appropriate for me to be responding to questions in the public comment.
Okay. All right. She can't answer your question at this time. Is there anyone else who wishes to speak? Okay. Seeing no further comment from those in attendance, I will ask the city clerk to read written comments received from the public hearing.
We did not receive written comments for the LPA hearing tonight.
Okay. With no further comment, I invite members of the city commission serving as the LPA to respond to public comment. Anyone wishes to respond today?
If you would like, I mean, I am prepared to answer those questions, I just didn't want them to think I was going to
Right.
answer them during public comment.
Right, no, this is your chance, please.
And I wasn't trying to be disrespectful, this procedurally, I'm not supposed to answer those questions during the public comment portion. A couple, just to answer some of those questions, first of all, I think we need to go back to the language that we're changing. These are special exceptions for two uses in two different zoning classifications, where the special exception criteria was based upon a property ownership question, not on a use question. That is why the case law was relating to that. All the other issues you brought up relating to the case law is not applicable. But I gave that to you because you asked, and I wouldn't typically do that, but I gave it to you because you asked. And I gave it to you because I wanted you to understand my perspective on this. The second thing, and this gets into some of the concerns that I keep hearing, code language and the code change, not just is changing nonprofit to accessory uses, but as it relates to docks, it's adding the following language. Docks and boating facilities of a private nature, that's the existing language. It is adding, for use by the residents of the residential community it serves. It's very clear within that language, notwithstanding anything else that's happening, in that language, that term accessory, for the purposes of docks, is not just related to that residential community, but for docks specifically, it has to be to serve the residential use. So the idea that it can come in and be something else under this code language, which in my opinion, my legal opinion, meets the case law that I saw, and it meets all those other criteria, would be very limited. So I understand your concern, and this is certainly a very, difficult thing to deal with when you're seeing this kind of change. This language is going to ensure that the uses are related to directly the residential uses. And it's only for those two things, so we're not worrying about the entire code, we're just worrying about those two issues, and that's what this would resolve. And I want to say a third thing as it relates to the monetary aspect of this, because I've heard that a lot at the town hall meeting, and I've heard it today, and I suspect we're going to hear it again. That is exactly the point. No municipality has the right to tell a private property owner how they can deal with or get remuneration for their property. That is why the case law that I reviewed was clearly identifying that it isn't the role of the city to get involved in that. And I understand that there may be frustration, but that frustration is not resolvable by this city commission. No, we're not going to get into a dialogue because this is a public hearing. I'm answering those questions so that you understand that. And I believe I said the same thing at the town hall meeting. But I want to make this record clear, and when it comes up again, I'll make the record clear there. I don't have another way to get you there, but that is the answer that I have to give legally. So with that, I don't have any more comments.
Okay, thank you. And nothing still from any of you before I move on? Okay. So before a recommendation is made, the LPA needs to consider a motion to affirm that adequate information has been presented and the public has been afforded a meaningful opportunity to participate. Do I have a motion and a second as such?
I move to affirm.
Okay. So I have a motion and a second. Is there any discussion on this item?
I'd just like to thank council for providing such a clear and concise way of understanding it. I know it's been a long road, and I appreciate the efforts so we can all understand it. So,
Yes.
thank
All
you.
the hard work that went in research. So Carly, if you can call the vote, please.
Nadir?
Yes.
Thomas?
Yes.
Thompson?
Yes.
Reed?
Yes.
Penny?
Yes. All right, so at this time, I call for a motion and a second to recommend either approval or denial of ordinance number 2024-03.
I recommend approve.
I'll second that.
Okay, any discussion on this motion? Okay. All right, so Carly, if you can call the vote.
Thomas?
Yes.
Thompson? Yes. Reed?
Yes.
Nadir?
Yes.
Penny?
Yes. Item number 2, this is ordinance number 2024-04. And at this time, I open the LPA public hearing for ordinance 2024-04 and ask City Attorney Mandel to present the item on behalf of the staff.
Thank you. This is an ordinance which is amending ordinance, commission, I got a little tongue
Spit it
tied
out there.
City Code, Chapter 130-46, Chapter 130-47, 130-48, 130-49, 130-50, and 130-51 of the code ordinances. While this issue has been kind of languishing for a while, it kind of came a little bit more to a head during our most previous special exception process, but it has been something I have been concerned about for some time. Your city code seems to have a glitch in it that is a long-standing glitch that had held over language from when you had a planning and zoning board. When you had a planning and zoning board, you had a separate meeting that there would be a recommendation to you as the commission on items such as variances, rezonings, special exceptions, and plats. When the Planning and Zoning Board was removed as an entity, for whatever that reason was, when the language was changed in your code, it just simply took out Planning and Zoning Board and put in City Commission, which is why we've had this kind of odd process where you would make recommendations to yourself on quasi-judicial matters at the same meeting. I understand that we're kind of doing that today, but let me just explain why this is different. You're statutorily required to do this. I can't change it. But other than the statutory requirement, that is only required for land development code amendments and for comprehensive plans. For all the remainder of your quasi-judicial matters, you are not obligated, and in fact, it could create more problems than it resolves, to have that kind of dual hearing where you had a recommendation to yourself on the same night. I am recommending that that process be removed. I think it was in line with what was supposed to happen, but that glitch has been there for a period of time, and it really did get highlighted during this process. So it is my recommendation that we go ahead and adopt or recommend to adopt that, and that I don't know that anybody really enjoyed the process of sitting here for 2 public hearings at the same time on the same night. So I think that will help to make your process a little bit more easily understood by folks. So again, I recommend approval of this ordinance amendment.
Thank you. So now I invite members of the public to comment on the item. Okay. Seeing no comment from those in attendance, I will ask the city clerk to read written comments received from the public hearing, if any.
Did not receive any written comments for this LPA hearing.
Okay. With no further comment, I invite members of the city commission serving on the LPA to respond. To any comments or anything you have?
It's long overdue.
Yeah, well, I mean, I was here when we used to have the planning and zoning board, and it worked well, but we didn't use them very often. It's so far in between that it was hard to keep volunteers, and I understand why we switched, but it was always a kind of cumbersome type of set. So this will clean things up, make it one meeting instead of having to go through 2, and get it all out at one time. So yes, I think this is good. So before a recommendation is made, the LPA needs to consider a motion to affirm that adequate information has been presented and the public has been afforded a meaningful opportunity to participate. Do I have such a motion and a second as such?
Second.
Okay, is there any discussion at all on this motion on the table? All right, so I'll call, Eric Carly, if you can call the vote, please.
Thompson?
Yes.
Reed?
Yes.
Denier?
Yes.
Thomas?
Yes.
Kenny?
Yes. And at this time, I call for a motion and a second to recommend either approval or denial of ordinance number 2024-04.
Move to recommend approval.
Second.
Any discussion?
That's okay, she can second.
Any discussion on the motion on the floor? No?
Okay, no problem.
All right. Since there's no further discussion, let's see if Carly can call the vote.
Reed?
Yes.
Denier?
Yes.
Thomas?
Yes.
Thompson?
Yes.
Kenny?
Yes. Okay, this time I'm going to adjourn this special commission meeting as a local planning agency, and we'll call to order the regular commission meeting. All right, let's go to the big pack. All right. Okay, and I am calling this meeting to order now. Good evening, everyone, and thank you for joining us tonight again, since you're still here. And this time, we will open the meeting with an invocation followed by the Pledge of Allegiance. The invocation is by Commissioner Thomas.
Our Father, as we gather here in the heart of our city, we seek your guidance and wisdom. May our decisions reflect fairness and compassion for the well-being of our community. Amen.
Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Carly, if you can call the roll, please.
Denier?
Here.
Thomas?
Here.
Thompson? Here. Reed?
Here.
Kenny?
Here. All right, at this time, we're going to open the People's Forum. This is the portion of the meeting when the public can speak on anything that is not on the agenda. Is there anyone in attendance that wishes to speak for the People's Forum this evening?
I do, if I'm allowed to talk about public kayak law.
It's not part of the agenda, is it? Okay.
As long as it doesn't relate to any item that is on the agenda.
So,
You can start your comments and give your name and address, please.
okay, thanks. Good evening, Commissioners. My name is Sandra Chappetta. You know where I live? Oh, you need me to speak up? I'm sorry, I
Yes,
have a
please.
quiet voice. So, there's been some concern about public kayak rental access. And so, I think it would be to the benefit of the city and everybody here and all the citizens of South Pasadena to have it clear whether or not it would be allowed to have a public kayak at the Causeway Village Mobile Home Park. So, based on the change to code and based on, you know, the Stromo versus Columbia City, I would love to ask Jolia why that was included in our memorandum and what that was referencing.
Okay. We have to wait till we get to the end part. We have your question, though. Thank you.
Okay, thank you.
Okay. Okay, is there anyone else who wishes to speak? The People's Forum? Okay, I'm going to close the People's Forum. Move on to the agenda comment portion. And I will now accept agenda comment. This is the portion of the meeting that the public can speak on anything that is on the agenda that is not a public hearing. Is there anyone in attendance that wishes to speak for the agenda comment? Okay, seeing no one, I'm going to close the agenda comment portion of the meeting. Excuse me. Move on to the public hearing. We will now move into the public hearing portion of this meeting, and I ask the city attorney and city clerk to speak regarding the hearing process for the 3 public hearing items we have on the agenda this meeting.
All evidence admitted at these hearings will be kept by the clerk to remain part of the record. In accordance with Florida statutes, you are hereby notified that if the person decides to appeal any decision made by this board at this hearing, he or she will need a record of such proceedings. And that such purpose he or she may need to ensure that a verbatim record of the proceeding is made, which record includes testimony and evidence upon which the appeal is to be based.
If you'll be participating in our hearing for this meeting, if you could, please stand and raise your right hand. Even if you already did it, it's a separate public hearing, so we have to do it twice. So, raise your right hand and respond accordingly. Do you affirm that the testimony you're about to give before this commission will be the truth, the whole truth, and nothing but the truth?
Yes.
Again, if you'll be speaking, if you could provide us with a comment card, that would be great. We have some up here, there's more in the back.
Thank you, Carly. All right, item 1 is ordinance number 2024-03. So I'm going to open the public hearing for this ordinance and ask the city attorney to read the item by title and present it to the commission.
Yes, this is ordinance number 2024-03, an ordinance of the City of South Pasadena, Florida, amending Chapter 130-10 and Chapter 130-12 of the City Code of Ordinances pertaining to permitted uses, providing for severability, providing for an effective date. This is the second and final reading. For the purposes of this record, I would like to just reiterate all of the comments that I made at the previous discussion during the LPA, and also want to reiterate what this change is. What this change will do is it will provide that, and this is specific only to the 2 zoning classifications that I've described, 13010 mobile home, 13.5 mobile home residential district, and section 130-12 residential multifamily district, which changes the provision that allows for consideration of a special exception permit as an accessory use to serve a residential community limited to parks, public parks and playgrounds, and docks and boating facilities of a private nature, with the new included language for use by the residents of the residential community it serves. I did did provide a memorandum, not a memorandum, I did provide case law that is not a memorandum, but just general case law as it relates to my recommendation on this issue. My recommendation and the case law on that, that was provided relates solely to one issue. Whether or not one issue, I just want to say this again, because I think there's a lot of confusion with some of this. And that's why it is hard for non-lawyers sometimes to review case law and understand the context of it. That doesn't mean anything more or less than lawyers make up a lot of words at one time on occasion. But what the intent was and what it is, my legal opinion is based upon, and my concern is based upon one issue and one issue only. And that is whether or not a municipality has the authority to regulate the use of land by regulating who the owner is. I've heard comments about kayak launches and whether or not this would open up the rest of the city to public kayak launches because one of the cases related to a kayak launch. That is the facts of that case, not the facts of this case. The facts of the case are not what's important. What's important as I looked at those cases is the underlying determination by courts as it related to the one issue that I've raised, which is ownership interest, utilizing an ownership interest as the reasoning behind regulating the use of land. So I understand there might be confusion on that. I apologize for that confusion, but the confusion that is what is important is this change. It's not opening up anything else. I went through the code to make sure this concept of the nonprofit use was limited to these two areas for this purpose. I'm not saying there's not other stuff in there. I'm saying for this purpose. That is why I'm recommending this change. I hope I did take that opportunity to answer the question, and I would open myself up to any questions from the commission. But as I've previously stated, it's my recommendation that we go ahead and proceed forward with this as adoption.
Okay.
I did not, I said it, but I didn't say it completely. Yes, I want to do that. The clerk reminded me that typically when we do have these duality of hearings, we take the entire record from the other proceeding, meaning in this case, the local planning agency, and adopt that as a separate motion. So I would ask that that also occur before you take a vote, that you adopt all the evidence and testimony into this proceeding. And certainly it is a public hearing, so if anybody wants to get up and speak, they have that right, but you can adopt and take all that testimony from the previous hearing as we've done in other hearings.
So we can do that now.
No, you could do it now or after, see who wants to speak. That's fine. I think we've typically done it after people speak.
We've done it before, because that way people don't have to speak again, but if they want to, they
Then I'm
can,
gonna
but we've
defer
done it
to
before.
As long as they, okay, we're not going to deny anything.
Say
Okay,
all the same things, but it's up to
okay.
Yeah, why don't we go ahead and have that adopted in the record now, and if anybody wants to add to the record, they have the right.
So I need a motion and a second to adopt the previous information from the LPA meeting into this meeting.
I'll motion to adopt.
Second.
Any discussion on that item? Okay, Carly, if you can call the vote.
Leininger,
Yes.
Thomas,
Yes.
Thompson. Yes. Reed,
Yes.
Penny.
Yes. And I just have a question on what you talked about before we got to this. So in the uses, and it clearly says that you've had here, and this is old language, docking and boating facilities of a private nature, and then added for use by the residents of the residential community it serves. So boating facilities could include a kayak launch, canoe launch, paddleboard launch, if that's what they wanted for their residents in their community. But it doesn't say they can open it up to the public
Exactly.
at all.
You're allowed to ask for respect.
Right.
If I have one of those zoning classifications and I want to ask for docks and docking facilities under this new code provision, I can ask for those dock and docking facilities, whether it's for a kayak launch or for a boat, that's what they're asking for, and it would have to be ensured that those are of a private nature for use by the residents only. Whether or not it's a kayak launch type of docking facility or another kind of dock, it wasn't regulated before, it's not regulated now in that sense. It's
Right.
only what we're regulating is how it's used.
It's an amenity they would provide for their residents,
Amenity they would provide for the
their
residents.
residents. Okay, just wanted clarity on that. Thank you.
Could the residents ask for that, or would they have to go through the owner? to have
Only
him ask
the
for
owner
it.
would have the ability to make the application.
Yeah, they couldn't do it on their own.
Right,
Yeah.
because she had her question there about that.
Yeah, yeah. All right. Oh, we got through that. Okay. So in light of the city attorney's recommendation, we will move to the public comment portion of the public hearing. So members of the public wishing to speak for ordinance number 2024-03 are invited to address the commission. This is the,
I didn't get another one for this because I didn't realize we were having like three. Do you want me to fill one out?
I'll do it for you.
Oh, you're awesome. Thank you, Carly. Okay. Whenever you're ready.
Go ahead.
Okay. Good evening, Commissioners. My name is Sandra Chappetta, and I live at 3717 46th Avenue South, St. Petersburg, Florida. The biggest question I have, and I know you can't answer questions during this, but I think at some point in time it would behoove the public to know how that Strummel versus Columbia case relates to the use of the, in particular, you know, you're talking about the docking facilities is part of the memorandum, because if she's saying it only relates to the use, I still am confused as to why that was included. So if Julia would clear that up for everybody so that we know, I know you just asked the question and I really appreciate that. Now, thank you so much for that, Mayor Penny.
all right.
The public really wants to be assured that there is not going to be any public access where Strummel versus Columbia City could override codes or permit conditions. And I think the public has a right to know that answer to that question, whether or not that's possible.
Okay.
Thank you.
Julia, can you answer that now, or do we need to wait till that, we get past?
Well, let's probably get to the end of public comment, and then I'm happy to respond.
Okay, okay. All right. Is anyone else who wishes to speak? Okay, seeing no further comment, I close the public hearing for this comment. Is there any discussion amongst the commission?
Well, there seems to be an awful lot of emphasis on a kayak launch. And this, to me, is very clear that it is for use by the residents of the residential community it serves. End of discussion, no ambiguity. It's plain as day. They're not going to come and, I don't care what the case she mentioned, she used a lot of cases to come up with her legal recommendation for us as a city, which quite frankly, it not only strengthens the city's position by not potentially getting in trouble by regulating ownership, it protects you by strengthening the language that it's for use by the residents of the community it serves. So I hope we're all can see where we're getting with this thing, but I think this horse has been ridden pretty far out to pasture. And that's all I have on that.
Thank you, Commissioner. Anyone else wish to comment?
Works for me.
Julia, do you want to try to respond to that one item?
And I want to start by saying, I have to be very cognizant of the fact that the legal advice that I give is to my client, which is the commission. This is my commentary, but it is not legal advice. And that's why I typically would never do a memorandum like this, but I felt the concern of the community so strongly and so concerned that I went ahead and I kind of made a little exception to what I would typically have done. That being said, the case law that you see is informing a decision on one issue. That particular case that you're commenting on, there's a lot of different case law that directly talks about when you regulate the use of land as a governmental entity, that the property owner's rights have some precedence over that. And that was the intent of that case, because it did at least talk about it in a public context. It is not at this time, and nor do I believe in my 25 years having done this, and also taught at University of South Florida teaching planning law, do I have any concern as I sit here of that particular issue coming up? Because if I did, the first people I would be having that conversation with would not be you folks, it would be my clients over here, because my whole goal in life, which is why I understand what a hard issue this is to ensure the security and safety of our codes, and us looking at our codes. We have and I'm going to take a second more on this. We have very antiquated codes in the city. one of our goals coming forward, and I've been working with staff on this, and they also want to do the same thing in looking at all of our codes. But this particular case, while you read it that way, I am reading that just to give us more comfort and more advice that says we have to be concerned when you regulate the use of land, that you haven't regulated it so much that I've taken some property rights away. And in this instance, that is something that was enough of a concern on our recommendedness. That case standing alone doesn't mean what you're saying that it says, because it's not intended for that purpose. I don't have another way to answer you without going into a very, like, almost professorial style conversation, but that's the answer that I can give you today.
Thank you, Julia. Okay, I will now call for a motion and a second to pass and adopt ordinance number 2024-03 on second and final reading.
So moved.
Second.
Okay, any discussion on this?
I just want to let constituents here know that Julia did an excellent job trying to protect you and protect the owner. And she put a lot of thought into this and reading what she has here, and it says there has to be a sign there saying it is private, and you don't have to worry about the public coming in and using your docks also, which she did an excellent job.
Thank you, Julia. Anyone else? Okay, hearing none, Carly, can you call the vote?
Thomas,
Yes.
Thompson,
Yes.
Reed,
Yes.
Ettinger,
Yes.
Benny.
Yes. We're going to move on to item number 2. And at this time, I'll open the public hearing for ordinance number 2024-04. I ask the city attorney to read the item by title and present it to the commission.
Ordinance number 2024-04, an ordinance of the City of South Pasadena, Florida, amending Chapter 130-46, Chapter 130-47, Chapter 130-48, Chapter 130-49, Chapter 130-50, and Chapter 130-51 of the City Code of Ordinances pertaining to requests for variances, special exception use permits, rezonings, and subdivision approval, providing for severability, providing an effective date. This is the second and final reading. And before we proceed forward, I'm going to ask for a motion of the commission to take all of the evidence and testimony that was provided during the LPA hearing and have that moved into this record for today.
So moved.
Second.
Okay, any discussion on that? All right, Carly, if you can call the vote.
Thompson,
Yes.
Reed,
Yes.
Ettinger,
Yes.
Thomas,
Yes.
Benny.
Yes. In light of the city attorney's recommendation, we will move to the public comment portion of the public hearing. And members of the public wishing to speak for ordinance number 2024-04 are invited to address the commission. Nothing? Okay. All right, seeing no further comment, I'll close the public hearing for this item. Is there any discussion amongst the commission? Okay. All right, so I'll now call for a motion and a second to pass and adopt ordinance number 2024-04 on second and final reading.
Motion we,
Second.
Okay. Any discussion on this? All right, Carly, please call the vote.
Reed,
Yes.
Ettinger,
Yes.
Thomas,
Yes.
Thompson,
yes.
Benny.
Yes. Now we're going to a public hearing. This is quasi judicial. This is item number 3. It's consideration of application for amendment to the previously approved special exception. So at this time, I'll open the public hearing for the item 3 and ask City Attorney Mandel to introduce it.
Thank you. Before you is I'm bringing back the previously denied amendment to the special exception use permit, which was filed by Causeway Village LLC. You had a hearing on that matter way back when, last year, I think it was October 10th, where it was denied. As a result of that denial, the property owner, Causeway Village LLC, filed something that is called a request for relief under Florida statute. Florida statute section 70.51, here, I'm going to turn this way so I can also look at the audience and talk, because I hate to have my back turned to them. an action under Florida statutes known as the Florida Land Use and Environmental Dispute Resolution Act. Pursuant to that statutory provision, the city is obligated to proceed forward with two parts. One is a mediation process, and the second part is a determination as to whether or not the city acted in a manner which had a negative impact on the property rights of the property owners. We are also obligated as a governmental entity under that statute to appoint a special magistrate. In this instance, and it has to be a special magistrate that is both acceptable to the city and acceptable to the property owner. Once that was filed, we went ahead and Mr. Evelini, who is the legal representative of Causeway Village, and I chose a particular special magistrate by the name of Robert Eschenfelder. Mr. Eschenfelder is a relatively well-known local government lawyer that I have known at least through reputation for a long time, and felt that he would be a perfect person who had a good understanding of local government laws. And so upon proceeding forward to the required public hearing for the first stage of that process, which is a mediation process, Mr. Eschenfelder and I engaged in a discussion, and that is what, upon which he raised the issues as it relates to our code and whether or not there were some issues in our code and the provision for nonprofit. I raised that as part of this discussion because I wanted the context of how we got here to be part of the reconsideration. I'm calling it a reconsideration, but it's not really a reconsideration. The consideration of the previously denied special exception, and also as we are required to do under the statute, we are required to consider the special magistrate's recommendation. So you have in front of you a recommendation that came from the special magistrate, and you had the previous recommendation that came from me to amend our code to remove the nonprofit status provision in our special exception. And you also have conditions which have now been revised for the purposes of ensuring that the conditions that were part of the Causeway Village special exception are revised in line with the new code provision. Those are part, it should be right down in this. You'll see these in your packet as part of the exhibit to the ultimate requirement that we have an agreement, and that is also on your agenda today. Those conditions were specifically amended from previous conditions to ensure that we are meeting the new code provisions and no longer are having a condition which relates to the property ownership. And I'm going to go through a couple of them, and I'm going to be not too long-winded, but I think it's important to go through them. The first and most important part of the conditions is that the special exception use permit is approved pursuant to the ordinance which you just adopted, and so that it's clear that these are obligated to be in compliance with the new ordinance. The second provides that both the dock improvements and the submerged land must be owned by the same owner as Causeway Village or subsequent owners. As we've moved into an accessory use, those have to now travel together as one property. Otherwise, pursuant to the previous ordinances, would have had to been divided, and a different entity would have had to have owned the docks because they didn't have a nonprofit that had an ownership interest in the property. That no longer is an issue, and that has been resolved through the amendment to the code. Item number 3 is that again ensuring compliance with the code, that the boat slips will be rented or otherwise used by Causeway Village residents, and the slip shall not be available for the general public for use or rent. Most importantly, that the boats have to be registered to use the boat slips for a Causeway Village resident, and I believe that that is the way it's done in other places, and that is still, and that was a condition that was in there from before, so that remains, that is still part of this. That number 4, that there's a log of the boat slip renters and the boat registration information showing that the boat slips are used only by boats registered to Causeway Village with the proof of residency, and that list shall be updated annually, and we will have an opportunity to look at that list as we are meeting. The owner will post signs, and this is a new requirement, at the ingress egress points of the dock, which says, private property slips are produced by Causeway Village residents, pool and other guests. So we're not just saying it in code, we're not just saying it as special exception, but there's a sign that actually provides for that. Number 6 is the dock operating rules and regulations, should be consistent with the special exception permit and submitted as part of the building permit application. So they have to give that to us when they apply for their building permits. And any amendments shall be submitted to the city for approval. Number 7, number 8, those were old conditions related to the design and the size of the boat slips. Number 9 is, and this is, again, it was in here before, maybe it wasn't as clear as it was, but I think it's very clear now. No commercial uses shall be permitted in connection with the boat slips or docks. Both the code now is very clear that you have to have these have to be in conjunction with residential use, and they can't be used for commercial, and that's also a condition. Number 10, the dock and boating facility shall not include fueling or marine repair services. Those wouldn't be allowed under the code. They would have never been allowed under the code, but we're making it very clear within the conditions that that is not allowed. 11 and 12 and 13 relate to their other permits that they get outside of the city. I did add some language in here, just I think it'll make it clear for everybody that what those permits were, but may be extended by the FDEP, so that way if there's an extension, we're not gonna have to go back and redo this. So that I did add in here. And that issue we did talk about that a little bit, just to make sure that there was synergy between what they were having approved with other entities and us. Number 4, that the owner shall execute an operation and maintenance agreement that incorporates the conditions in the special exception permit for approval by the city commission and execution by the city. That agreement is also on your agenda tonight for approval, and it contains, and we'll talk, well, I can go ahead and talk about it now, so that way when you get to that item, you can just deal with it, but at least we're talking that through. That agreement does a couple of things. One, that has these conditions as part of them. 2, it makes these conditions enforceable not just through a code enforcement action, but through a breach of agreement action. And the third thing that was part of our negotiation and settling of this matter, because this would fully settle this matter, is there's a provision in the agreement that says that this would be fully settling all matters between the parties as it relates to the special exception, and that each party will bear its own fees and costs, so that way we're not going to be in a position where, and I know Mr. Abellini would never do this, but just in case somebody wanted to come back for attorney's fees against us for this action, and that we wouldn't have that right either. So that would resolve all of the issues. That agreement has to also be recorded in the public record and would then run with the land going forward. So it would give us alternative and other opportunities to enforce these conditions. And number 15, it's a statutory provision, but that issue did come up in some of the conversations that I heard, that liveaboard vessels are prohibited. They might be anyway, but just to make sure that we're circling on that. One of the big issues that was in the previous conditions that we did remove, just in case anybody here had concerns about it, or it was an issue that somebody might hear about. The previous conditions, because the whole provision would have required the property owner, Causeway Village, to actually separate out their property and have a different ownership interest, we did allow the opportunity for condominiums. That actually ended up being quite some concern. That provision, and in fact, that I think was actually a recommendation of the city attorney's office, just to be able to deal with that issue going down the line. That has been removed, and I think that did cause some consternations for some folks. That wasn't even something that Causeway Village asked for. It was really just something we thought from a housekeeping would make some sense, but that has been removed. And I want to make that statement for the record, since that happened to have been a very significant issue. I understand that what I've asked of you, both in the previous amendments and in the approval of this amended special exception, is something that was not necessarily the desired outcome of the community or of this commission. At the time we were hearing the previous special exception amendment in October. The code said what it said, and the recommendation that I made that the conditions that were requested didn't meet the code remained, at that time and remain today, important. That is why my recommendation to move this forward, to settle this matter, and to ask for you to recommend that you approve these new conditions had to be related to the code amendment, not related to a variance. And I understand some of these folks have said, well, why can't you just approve this and not change the code? If it was the code that was flawed, the code needed to be fixed. Otherwise, this would have been deemed a variance. And my whole premise of bringing this forward this way was to make sure that your code is as legally defensible as possible, not to just settle this so we didn't litigate it. And I'm not saying I will always take that position. I'm saying in this instance, it was important that we clean up a provision of the code that had some legal challenges and questions to it. So with all of that, with my explanation, with the previous, and I want to say for the record, all of the previous documents that were in your old records for this matter have been included into this quasi-judicial matter so that all of that record exists. The recommendation of the special magistrate, the conditions, and the agreement that will be actually taken up later today are all as part of this agenda item. And I'm available for any questions. Thank you for allowing me to go through that more lengthy explanation, but I think it was important not just for everybody here, but also for the purposes of the record, just in case something should come of this.
Nope, thank you very much, Julia. All right. So at this time, I'm going to invite the applicant to present their application to the commission.
If you want to speak, this would be your time.
Check my phone, I think it's still good afternoon. Nope,
Yeah.
6 o'clock. All right. Mark Abellini, representing Causeway Village MHC LLC, owner of the Causeway Village Mobile Home Community. We do accept the conditions that have been revised by the city, and in fact, I will note that the no commercial use shall be permitted was actually added by me. So we accept these conditions, and we're glad we were able to resolve the matter, and we look forward to, proceeding with the project, following up on the approval we need from the county. And I can answer any questions, but, as one Commissioner Reed stated, I think the horse has been ridden.
Yes, we've seen it, we've read it. Thank you very much.
Thank you.
That's good.
Okay. Is there any presentation from the staff?
I think I gave the presentation that I probably should have given at this time.
That's the one you, okay.
Just gave it.
I'm just trying to move us along.
Any other staff wish to speak? No? Just sit back there quiet? Okay. All right. Those wishing to speak in favor of the application are now invited to speak. Okay. Seeing no one. Those wishing to speak against the application are now invited to speak.
Here we go.
Hello again. Oh, we have these. And I have the card. Okay. Let me get organized. All right. Okay, I'm ready.
Okay, go.
Good evening, Commissioners. Again, my name is Sandra Chapetta, and I live at 3717 46th Avenue South, St. Petersburg. It's the intent of City Code to provide private docking facilities for multi-residential communities for use by residents only, to retain the residential nature of communities, and to protect public safety by ensuring revenues collected are only used for maintenance and repair and not siphoned off as profit. Any use of the Causeway docking facilities must also be compatible with the surrounding use. All the docking facilities in this part of the bay are restricted to private resident use only, with no public access and no commercial use allowed. The public thinks the docking facility will be private, but there are no permit conditions that restrict use of the entire docking facility to residents only. The conditions only restrict use of the slips. Does this mean that the general public will be allowed to access the main dock, observation deck, or kayak launch? Condition 3 really should be changed to state that docking facilities shall not be available to the general public for rent or use. Condition 5 should be changed to state the owner will post sign at the main dock entrance and at the egress point of the docks, which will state private property. The docking facilities are for the use by Causeway Village residents only and their guests. This will eliminate public access. Condition 7 was removed because of the word ownership. It should remain and be changed to if potential future conversion or rezoning that includes residential use is addressed, the same use restrictions would apply, upland residents only and transferable only to another resident. Condition 9 prohibits commercial use. Would the commissioners please answer if a public kayak rental would be considered a commercial use? In an email dated 9/17/2016, the developer asked if there's any way slips can be rented out to the public, and he stated any future redevelopment would capture the use of the docks relative to whatever upland plan was conceived. The Mobile Home Park property has not been rezoned yet, but it was placed under the proposed mixed-use plan redevelopment overlay in March 2015. That drawing includes a proposed public marina. See attachment 2 and 3. The increased use, traffic, and noise a public docking facility would create is clearly inappropriate in the middle of a residential corridor. It would also be incompatible with the Tampa Bay Estuary Program that designated the shared public natural resources on the owner's submerged lands a protected restoration target area for seagrass in 1995, incompatible with the county's water quality goals for the Pinellas County Aquatic Preserves, and incompatible with the need to protect endangered manatees that use the channel daily from boat traffic that would be much less with private use only. Please ensure conditions are in place that protect the public interest by ensuring the docking facilities are private use for residents of the upland only with no possible current or future public or commercial use, even if the property is rezoned to mixed use. So would a kayak launch, a public kayak rentals, would that be a commercial use since it's for compensation? Thank you.
Anyone wish to, what do we got next here? So the applicant may now speak in rebuttal.
I have no rebuttal, I think I was pretty clear.
Okay. Are there any closing statements at all from the applicant?
No one has ever called me bashful, but I'll just say that, again, I think these conditions are clear. You've reinforced it with your number one, your condition number one, which ties it to the accessory use. We have the restrictive covenant that's recorded in the public records, belt, suspenders, and what else more can you have? So I think we've, secured the intent. This is what is our intent. It wasn't us in the 2008, 8 years ago, whatever it was. So I think we have a good document and a good foundation.
I believe right now, don't you guys already have some type of a signage in the front of your property that says private property?
Yes.
So only invitees only or whatever kind of thing. So I thought there was something there. So, and one time I wanted to drive it and look around, I was like, oh, well, can't do that. So just left. But thank you. Okay. Any closing statements from staff?
Thank you. I don't have anything else except to reiterate that I think these conditions meet the intent of what is in the current code that you just adopted. And just to answer the one question, you can't rent this. If you're renting it, it's commercial. Whether it's the fact that it's a kayak versus a boat really doesn't matter. So
Right.
I understand the stress about it, but that's just simply not what this is providing for.
Right, to put a public entity on a private property, I think was the question, right?
Sorry?
Well, the question was to put a public entity on a private property or a public kayak launch on private property. It's,
We would have no authority to put our public kayak
Yeah.
launch onto this, and it would then no longer be an accessory
Yeah,
use.
well, yeah,
It's
and,
residential property that it's serving.
right, and it's pretty clear. I mean, it just says that it's only for the residential community itself. And that's all boating facilities, no matter what it is, whether it's canoes, kayaks, or whatever. It's only for the residents of that community. So I think that's clear.
Yes.
Okay, thank you. All right. So at this time, I'm going to close the public hearing for this item. Is there any discussion amongst the commission itself?
If I may indulge for a moment.
Did anybody else want to speak? Nobody must have asked if anybody else wanted to speak.
Be glad to let somebody else come. Do you want to speak?
I didn't know if anybody got there, I was just.
Okay.
For them.
All right. Go ahead, Tom.
You know, this has been an issue was one of the first issues I had on my plate when I was elected back in 2020. And I know we've gone back and forth, and I appreciate everybody coming in and sharing their opinions and thoughts and all this, and I know it's a contentious issue. But I think the important thing is we went one direction, the applicant was able to avail themselves of a court proceeding, and now we've reached an agreement. But I'm looking here from the special magistrate, who's highly respected, and indulge me for a minute. As the special appointed magistrate, it's my strong recommendation to the city of South Pasadena that the commission implement the terms of the proposed resolution. I find that if implemented, the proposal will not only resolve the assertion of undue burden presented by the owner, but will also greatly strengthen the city's position relative to future application of its land development code, while continuing to ensure the unique character of South Pasadena. And then the final paragraph, and city attorney can tell me if I'm reading this right, and I'll paraphrase it. If for whatever reason the parties do not take forth the action, he will reconvene the hearing, complete the proceedings, and basically decide, which would mean none of us might get anything that we'd be happy with if we don't take this action today. So while I know not everybody's getting what they want in this equation, everybody has certainly worked hard, you folks in the audience included, and I think we've gotten the best that we can possibly hope for, for all parties. So thank you for all of your input.
Very well said. Thank you, Tom. All right, anyone else? No? Okay. All right, I'm now going to call for a motion to either approve or deny of the application for an amendment to previously approved special exception from Causeway Village Mobile Home Park LLC for 1375 Pasadena Avenue South, South Pasadena, Florida, 33707.
I'll make the motion, we approve.
Second.
Okay, any discussion on this motion? Hearing none, Carly, can you call the vote?
Einiger,
Yes.
Thomas,
Yes.
Thompson,
Yes.
Reed,
Yes.
Penny.
Yes. All right, so we move on with our meeting. So we have no unfinished business, no consent agenda. We do have some new business, though. We have item 4, which is resolution number 2024-02, and I'll ask the city attorney to read it by title.
This is resolution number 2024-02, a resolution of the City Commission of the City of South Pasadena, Florida, certifying the proposed millage rate to the county property appraiser for fiscal year 2024-2025.
All right. During the budget process in June, the city commission evaluated potential millage rates, for fiscal year 2025. The proposed tentative millage rate discussed during the budget process and listed in resolution number 2024-02 is 5.1750. And right now, do I have a motion and a second to pass resolution number 2024-02?
Motion.
Okay. Is there any discussion amongst the commission?
Did she make it or did I
I
make
did
it?
it.
I thought I heard it first over there, but whoever you want to pick.
Whatever.
1, 2.
Did 1, 2.
1, 2 will be fine.
Thank you.
Yes.
Okay, I do know that we went through a very long process, as we
Yeah.
usually do with the budget, to make sure that everything was covered and we would have the funds we need to operate the city in a financially responsible way.
Jim is to be commended.
And this is just setting for posting. Of course, the millage rate right now, it can always be lowered, it can't be increased. This locks it in. So unless there's any other discussion from anyone, I'm going to call the vote.
Thomas,
Yes.
Thompson,
Yes.
Reed,
Yes.
Einiger,
Yes.
Penny.
Yes. And item number 5, this is a A motion for Causeway Village private docks, and I'll ask the city attorney to read the motion.
This is a motion to approve an agreement for the operation and maintenance of Causeway Village private docks between the City of South Pasadena and Causeway Village, MHC LLC. This has been previously discussed and would simply have you adopt and approve the agreement that would be required by the special exception you just heard.
Okay, so do I have a motion to accept the motion as read by our city attorney?
So moved.
Second?
Second.
All right. Any discussion? Okay, call the vote, please, Carly.
Thompson,
Yes.
Reed,
Yes.
Hattiger,
Yes.
Thomas,
Yes.
Penny.
Yes. Okay, we're going to move on to item 6. This is the Florida League of Cities voting delegate. And I'll ask the city attorney to read the motion.
This is a motion to appoint Mayor Arthur Penny to serve as the city's voting delegate at the annual Florida League of Cities Conference to be held August 15th through 17th, 2024 in Hollywood, Florida.
All right, do I have a motion and a second?
So moved.
Second.
Okay, any discussion on this item?
Look forward to seeing you down there.
Yes. You think this packet's thick? All right, can you call the vote, please, Carly?
Reed,
Yes.
Hattiger,
Yes.
Thomas,
Yes.
Thompson,
Yes.
Yes. And item 7, this is a motion for the special planning project and Ford Pinellas. Can the city attorney read the motion?
This is a motion to approve special planning project agreement between the City of South Pasadena and Ford Pinellas.
All right, and do I have a motion and a second on this item?
Make a motion.
Second.
Okay, we have a motion and a second. Is there any discussion on Ford Pinellas? All right, hearing none. Carly, can you call the vote, please?
Hattiger,
Yes.
Thomas,
Yes.
Thompson,
Yes.
Reed,
Yes.
Penny.
Yes. Okay, at this time, I am going to adjourn. Thank everyone for their coming here this evening.
This didn't last till midnight.
Back to where we